Okay, so good morning and welcome to today's webinar. This is a series from probono.org to be discussing HIV, AIDS and TB. And today we are joined by two very well-known speakers in the field. That is Morgan Courtney from Bridge Group, and he's also in-house counsel for the Child Law Centre. And we have Shanice Linderboom, who is an attorney at Section 27, and they will be discussing various aspects of legislation that protects children living with HIV/AIDS. So before we get started with today's webinar, I'm going to hand over to Teresa Yates, who will be giving an introduction of probono.org and also this project. Teresa?
Yes, thank you, Chantel. Good morning, everyone. I'm just going to give just a short welcome to the participants and to also let everyone who's on the call know that the webinar is being recorded so that if you want to listen later, that will be available as well. I'm Teresa Yates. I'm the director of probono.org. I just want to welcome everyone and to thank Morgan and Shanice for taking time out of busy schedules to provide information and guidance related to legal issues that affect children living with HIV and TB. This webinar is part of a series that has been convened to raise awareness and to educate legal practitioners and the public about key legal issues related to discrimination and stigma faced by people in South Africa who are living with HIV and TB. It's part of a larger program that is funded by AIDS Foundation of South Africa through a generous grant from the Global Fund. And Pro Bono's role in the overall project is to raise awareness and to provide legal services for people key and vulnerable populations in South Africa who are affected by discrimination based on their HIV and or TB status. So we just want to thank Chantel D'Souza as well for convening these webinars and organizing the animated series also that have been published on the various legal issues as well. So with that, I will turn it over to our presenter, and thank you again for joining us today. And you'll see if you have any questions or you'd like to get in touch with probono.org after this workshop, you'll be able to reach us on through our website. You'll find our contact details, and the website information will be, I think, posted at the end of the webinar. If not, you can go to www.probono.org and you'll find us. Thank you.
Thanks, Teresa. Morgan, if I can hand over to you to get us started.
Thank you, Teresa. Thank you, Chantal. So I've been asked to provide a kind of high-level overview, I suppose, of what provisions particularly play an important role with children living with HIV, AIDS, and TB. Now, in analyzing kind of the question, I found that no discussion about HIV, AIDS, and TB in particular would be complete without actually drilling down to how does one access these services that are fundamental to promoting one's health if one suffers from that, as well as then obviously the confidentiality provisions. So in order to make an assessment, one needs to look first and foremost at the issue of consent. Consent is pivotal, particularly in the realm of protecting one's rights to healthcare and to privacy in particular. And the issue of consent is dealt with extensively in the Children's Act. The Children's Act creates a system that governs effectively child participation in various spheres. And in this regard, and of importance for today's discussion would be the sections relating to healthcare generally and HIV and AIDS in particular. And those provisions are generally well known, but they are sections 129, sections 130, 132, as well as sections 10 and 31 of the Children's Act. I will deal and touch on each of those provisions in a bit more detail, but just by way of a background. So obviously central to today's discussion is like I mentioned, is the issue of HIV and AIDS, as well as TB. But what the Children's Act does is it particularly focuses or has provisions relating to HIV testing. So I thought a good starting point, considering that one of the thematic areas is HIV, is to start off by kind of discussing what the law allows for insofar as HIV testing is concerned. Now, HIV testing is governed by Section 130 of the Children's Act. And effectively what the provision allows for is that any child over the age of 12 years old is entitled to be tested for HIV without any form of third-party intervention. So without needing the approval or consent of their parents or any other person who may be authorized by law to grant consent. It also, though, makes provision for a child in circumstances where it's in the child's best interest, who is under the age of 12 to go and be tested without consent. And what the legislature has done there is it has introduced this kind of quote unquote maturity test to determine whether or not a child is capable of effectively giving informed consent to the testing process. Now, the Act itself is silent as to how does one actually determine whether or not a child is mature enough in order to make that decision. And it's often left in the hands of healthcare practitioners. That in itself obviously has several problems, because how one healthcare practitioner approaches an assessment of maturity and that of another who approaches the very same problem may differ. And it is a possible area of concern going forward, particularly where children are being discriminated against just on the basis effectively of their age and of not being able to gain access to the testing. It's not to say that children are completely excluded under the age of 12. They and children who are found not to be mature enough to consent to the testing, they can still obviously obtain the requisite consent from their parents, and there's an option for ministerial consent as well as the court to deal with that particular issue. But within the confines of, within the context of children trying to access that service, and for whatever reason they do not wish to involve third parties, the problem that arises, and as I've pointed out, relates to how does one then sit and gauge whether or not a child is mature enough to give their informed consent. And unfortunately, it is a question without an easy answer. We've had discussions with several medical practitioners in order to gauge how they would approach the problem. And most of them are of the firm view that the issue of effectively capacity is a legal issue and has no place in kind of their medical practices. So what we are seeing is that children who do wish to be tested, who are under the age of 12, often are turned away on the basis that they are too young to consent, and that the medical practitioner, for fear of reprisal, does not want to engage them and finds that subjectively they do not have sufficient maturity. And that is something that we are looking into, and it is something that we think needs to be developed going forward. Allied to the issue of maturity and where one would think a determination of whether or not a child is mature enough to consent to being tested are the provisions of Section 132, which provide that every child who wishes to undergo an HIV test must be counseled both before and after the testing is complete. So Section 132 effectively serves a dual purpose. One, it provides an opportunity to make an assessment, particularly, well, for those children who are under the age of 12, to make an assessment as to whether or not they're of a sufficient maturity to be consenting to this particular test. And two, it obviously provides the necessary support structures for the child in the event that the child is or does test positive for HIV. A third kind of important aspect that is dealt with by the Children's Act, particularly in the context of HIV, is the confidentiality provisions. And those are governed by Section 133 of the Children's Act. And what one would see is, if one interrogates that particular provision, is that a child has almost an absolute right to privacy insofar as his or her HIV tests are concerned, and that cannot be disclosed as a general rule to parents and or caregivers or guardians or to any third party for that matter. And the reasons are obviously quite clear, is that we live in a country where HIV/AIDS does often result in people being ostracized and excluded on the basis of their HIV/AIDS status. And the law there seeks to protect them in most instances. There are obviously exceptions to the general rule, but as a general proposition, a child has an absolute right for his or her privacy to be respected insofar as those test results are concerned. And that would obviously apply regardless of age, if the child had in fact consented. Obviously, HIV testing is, I guess, the entryway when discussing, or the path of entrance when discussing aspects to HIV/AIDS and TB. A second important part of the Act deals with the medical treatment and consent to medical treatment. Now, those provisions, or that provision, is dealt with in Section 129 of the Children's Act. And it importantly goes hand in glove with the testing provision, because it's all well and good that a child may be able to test for HIV without the consent of his or her parents. But it would end up being a hollow victory for that child if the child would have to disclose his or her HIV status, despite not wanting to, in order to seek out medical treatment. And in that regard, there does seem to once again be a disconnect between the legislation, or the various legislative provisions. Section 129 Section 129 provides that a child who is over the age of 14 or over the age of 12 who has sufficient age and maturity. So it's a dual test. You must be over the age of 12 and you must be sufficiently mature to consent to the medical treatment in order for you to access it without assistance by a third party. So children, for instance, who are under the age of 12, who may lawfully apply or may lawfully be tested because they have been judged to have sufficient age and maturity, may find themselves in somewhat of an anomalous situation where, for instance, the child is 11 years old, the particular medical practitioner has judged this child to be of a sufficient age and maturity to consent to HIV testing, has tested positive, and then is unable to access medical treatment because the child is under the age of 12. And for whatever reason, that child may not wish to disclose that to a parent or a caregiver. The anomalous situation has not yet, as far as I'm aware, resulted in any form of litigation. So whether or not the problem is more perceived than real is yet to be determined one way or another. But it does demonstrate the importance of the legislature properly unpacking and making sure that there is some measure of coherence between the various provisions in the Children's Act. Insofar then as Section 129 is concerned, and leaving the anomalous situation of children under 12, the Act obviously there also provides then that children may consent to their own operations, their own medical treatment arising from a diagnosis of HIV/AIDS or TB for that matter. The question that is often posed in relation to the obtaining of consent is, what if the child does not have the capacity, and how does one go about resolving that? And once again, it is a rather fact-dependent question, and depends very much on the context that the question arises. What we know is that obviously children who are under the age of 12 and cannot themselves consent to their medical treatment, or are over the age of 12 and have been judged by the medical practitioner not to be of a sufficient age and maturity to consent, that there the legislature has adopted an approach that one must then obtain either parental consent, ministerial consent, or have the consent of a children's court or high court deal with the matter. Once again, it is in the context of violations. It is not an ideal situation for a child to find him or herself in. And perhaps with reference to the example that I gave when discussing the HIV testing, it is judging whether or not a child is capable of giving consent, and informed consent, which is obviously a prerequisite for any medical procedure, regardless of whether you're a child or an adult, often depends on the subjective whim of the medical practitioner who is seeing you on the day. So once again, you might find yourself in a situation, a child might find themselves in a situation rather, that the HIV testing, the medical practitioner that dealt with that particular test found that child to be of a sufficient maturity in order to give that consent. And you might then find, when the child goes and seeks treatment, that the second medical practitioner might form a differing view. Now, once again, there is no easy remedy. There is no easy access to justice remedy at the very least, because the only remedy that the child would effectively have would be either to disclose his or her status to his parents or guardians or caregivers in order for them to assist by giving their consent to his or her medical treatment, or to approach a court and disclose it in court papers, which is obviously less than ideal. And I think that it does present an area that once again needs to be interrogated in more detail, and an analysis done as to whether or not children are falling through this particular gap. If they are, then there is obviously a need for either some form of intervention, whether it be through litigation or some form of advocacy process. But in a nutshell, it is a very real situation that children may very well find themselves in. And it unfortunately at this point in time doesn't have a very easy remedy for that particular child concerned. Another issue, or the kind of third issue that one needs to deal with when discussing HIV/AIDS and TB and medical treatments generally, is the role that the child has in the decision-making process. Obviously, I've discussed the instances where children are entitled to consent, and those are relatively then straightforward. Once a child is able to consent, so in other words, in the testing environment, that they're over the age of 12, or if they're under the age of 12 and are found to be of sufficient maturity, or in the context of medical treatment, where they're over the age of 12 as well as have the necessary maturity in order to make those kind of decisions. Those children should then be able to access the various medical services that they would require going forward without any further intervention. However, if a child, for whatever reason, is not, for instance, mature enough to make a decision. That is not to say that that child has no say, and for instance, that their parents or caregivers are entitled to dictate exactly how things should unfold. What we have there is we have Section 10 of the Children's Act reaffirms the principle that all children ought to be entitled to participate in any major decision that involves them. And the Children's Act expressly requires that they be consulted with, and that whatever their views and wishes are, that they at the very least be considered. Now, it may be a very cold comfort for children in that type of space to merely be consulted rather than dictating their own lives. But it at least does provide an opportunity in order to elicit the particular child's views as to how, for instance, treatment, TB treatment or HIV treatment should be dealt with going forward. Unfortunately, or fortunately, whichever side of the coin you fall on, is that the parents or the persons holding parental responsibilities and rights in respect to the child would obviously have the overriding decision. But insofar as child participation concerned, it is at least a positive step that they ought to be consulted. Whether in practice that always occurs is something that I guess once again will be very factually dependent, because there is no prerequisite, as far as I'm aware, that a healthcare provider needs to ascertain whether or not Section 10 had been complied with. The last aspect that I wanted to touch on, which I felt was important in the context of the discussion of today, was whether or not a child may refuse treatment of whatever kind. Now, it might be a rather bizarre proposition to make, particularly in the context of HIV and AIDS and TB. But I think it is an important discussion that needs to be had, that children also have the right to refuse whatever treatment. And that is also implicit in Section 129, as insofar as the child is allowed to consent. The corollary is then obviously also true. And Section 31 of the Children's Act also empowers the child to a degree to refuse to undergo whatever medical treatment may have been prescribed. And in the context of these types of diseases in particular, there are often, and one hears of often, of various treatments that are prescribed by, in broad brushstrokes, healthcare practitioners that might not have scientific evidence. So once again, the importance of a child being able to refuse a particular treatment then becomes kind of paramount in an assessment as to whether or not a child should be compelled to undergo some form of treatment that he or she does not wish. So if, for instance, there is some homeopathic cure or homeopathic medication that is touted to alleviate the symptoms of TB, or bizarrely to cure HIV and AIDS, a child hopefully would be given an opportunity, if his or her parents were trying to make use of that, to be able to reject that proposal. And once again, it assists the child in determining his or her own future, obviously with the necessary safeguards in place. I think at the end of the day, it is important when discussing these kind of health concerns to bear in mind that whilst we accept that children have autonomy and self-determination, that they should be allowed to, as far as the law allows, to express themselves and for their views and wishes to be seriously considered. There may be instances that their views are tainted by yet uninformed decisions, but one must be very careful in judging children just because of their age to have rather immature views. And just accepting that adults, just merely because of age, do not themselves hold such particular views going forward. So for those who are present, who are in the medical field, I guess my my parting words would be that when confronted with a child, ensure that you do not judge those particular childs by a standard that not even a parent, not even an adult your ordinary adult would be able to pass. Because at the end of the day, you would simply be denying them access to vitally important healthcare services that may well, assist them later on in life. And I think that then brings me to the end of my presentation.
Okay, thank you, Morgan. That raised a lot of interesting questions, and I'm sure we're going to get quite a lot from our participants this morning. So we'll have a Q&A session just after Shanice speaks, and then just to the participants, you can either raise your hand or just put your question in the comment box, and we'll pass them on to the presenters. So now I'm going to hand over to Shanice Linderboom from Section 27, who's going to focus on aspects of education in relation to children living with HIV, AIDS, and TB. Shanice, can I hand over to you?
Good morning, everybody. Thank you so much, Chantal and the probono.org team for this invite. I just want to try and share my screen.
Yeah, sure, you can go ahead, Shanice.
I don't know if people can see.
Not yet. It's not showing yet.
Sorry about this, guys. Okay, maybe I should just chat. Is that fine? Can I just go ahead?
Yeah, that's perfectly fine. We can add the presentation to the website.
Okay, lovely. Thank you so much. Okay, so sort of my brief was just to speak about the framework around protection against discrimination in the education sector. So I think just to start off, it would be worth noting that I think it would be fair to say that unfair discrimination has shaped not only South Africa as a country, but most definitely the South African education system. I pulled out a quote from the Hoërskool Ermelo case, which sort of described the system and its unfortunate consequences. So just to say, it's so that white schools were hugely better resourced than black schools. They were lavishly treated by the apartheid government. It's also true that they were served and they were shored up by relatively affluent white communities. On the other hand, formerly black schools have been, and by and large remain, scantily resourced. They're deliberately funded stingily by the apartheid government. Also, they served in the main and were supported by relatively deprived black communities. And that is why perhaps the most abiding and debilitating legacy of our past is an unequal distribution of skills and competencies acquired through education. And I think working in the education space, we see the impact of unfair discrimination to this day. I think race is the most visible marker of inequality, but most definitely unfair discrimination on the basis of gender, religion, language is quite prominent. Sexual orientation, disability, and what we're here to talk about today, HIV, and many other grounds, is a constant feature, unfortunately, within the education system in South Africa. I just wanted to quickly just pull out, in terms of international law, there are several international instruments that sort of expressly prohibit discrimination in education. And this would be on the listed grounds, which would include HIV. And they require sort of a positive measure to promote equality, and which South Africa has ratified these instruments. So that would be the International Covenant on Civil and Political Rights under Article 26. the International Covenant on Economic, Social and Cultural Rights, which is specifically where we would see the right to education feature quite significantly. And this is covered under Article 2. And then the Convention of the Rights of the Child. This is also under its Article 2, which, as I say, really just sets the scene for prohibition of discrimination in education and require positive measures from the member states. And then I think just to speak to what our sort of our guiding light is in respect nationally, we'd be referring to obviously the Constitution. The right to equality is guaranteed under Section 29, as we, sorry, I beg your pardon, under Section 9, as we are all aware. And I think that, you know, if we break it down, there are sort of three significant parts, which is to say that everyone has a right to equality before the law and its equal protection. This is under Section 9(1). Secondly, that the permission for the state to take positive steps to protect and advance certain groups that have been disadvantaged by unfair discrimination. And then we see that in Section 2, and this would be things like affirmative action, which we know there's been quite a bit of litigation on in our courts. And then thirdly, a significant feature is that the prohibition of unfair discrimination, both by the state as well as by private individuals. And this will be covered under Section 9(3) as well as 9(4). But in the context of the discussion today, I think it's worth also mentioning or seeing the overlap then that would come from, for example, the right to dignity, that the impact that would have, the best interests of the child, which is Section 10, as well as the right to health, Section 27, and then the right to education, which we're going to be speaking a little bit more about. So, you know, from, I think, as we all know, with our rights set out in the Constitution, we have a legislation which then gives effect to that right. And in particular, the right to equality, we have the Promotion of Equality and the Protection from Unfair Discrimination Act, or the Equality Act. So this act was specifically enforced to give effect to the constitutional right to equality. It not only prohibits unfair discrimination by states and individuals, but also then sets out positive measures that need to be placed to promote equality. And it also sets out a network of courts in which would allow for individuals to sort of seek recourse should their rights have been infringed in these instances. In this particular act, Chapter 5, which is positive measures, so what we would see, my understanding is that it's still not enforced, but it would indicate types of actions that we would want to see in schools that they need to adopt to promote greater equality. So we'd be looking at putting in place plans and policies to address unfair discrimination and to promote equality, proactively monitoring policies and practices to ensure that they don't discriminate unfairly, promoting access for learners from all backgrounds, providing adequate training and assistance to teachers and staff members, and integrating equality and unfair discrimination lessons. In lessons, sorry. And I think what we'll see as we go through the presentation is that already there's quite a significant number of this taking place in the education landscape. So just to say, there's a very close link between the right to basic education and the right to equality. We have already said that states must provide basic education to all, and importantly, without unfairly discriminating against any learners. We've seen instances, unfortunately, where there has been unfairly discriminating learners, specifically around issues like access. The recent Phakamisa judgment, where we saw that learners that did not have any documentation were not allowed to enter into, or were not given access into the education, into the schools. And this was said to be unlawful. So it's things like this where we're saying that there must be no unfair discrimination against any learners. Unfair discrimination in schools will obviously impact on the learner's rights to receive basic education. If we look at the right to basic education, it's a basket of entitlements that make up the right to basic education. It includes things like infrastructure, furniture, textbooks, teachers. All of these elements come together to encapsulate what the right to basic education looks like. And an important feature of that is safety in the learning environment, right? And if one is, if we look at on the issue of access itself, firstly, not even being allowed to enter into the schooling system because of your HIV status, that is most definitely impacts on one's right to basic education. And then, for example, being in the schooling system, having to deal with issues of safety, stigma and discrimination, most definitely would have an impact on that child's right to properly receive the right to basic education. So it's just to just contextually to understand how the link between those two. So, and then I think although HIV is not listed as a ground in the Constitution under 9.3, it has been held to be an analogous ground for discrimination. And I think a similar argument can be made for, obviously, TB status and health status more broadly. Just briefly to touch on equality in education. So the goal is substantive equality, right? And I think what we need to be, the things that we need to be thinking about is that, firstly, there needs to be an equal enjoyment and protection of your constitutional rights. We've said that this is endorsed by Section 9.2 in the Constitution, and that all learners should receive basic education. Then accommodating and valuing difference, rather than treating individuals or everyone identically and promoting uniformity. Schools that attract learners from diverse backgrounds can promote an understanding and tolerance, and then learners in diverse schools are better equipped for a life in a diverse country. And an example that I'd like to give here is the inclusive education model, where we see that, for example, it's not just to say that all children with special needs need to be placed in a special school. The idea is that, for example, with the CS policy, the screening, identification, assessment a policy, which then requires one to assess the learner, establish what their needs are, and reasonably accommodate them in a mainstream school, not necessarily, putting all, like I say, learners with special needs off into one school and not being given an opportunity to be in an environment where they're engaging with different people from different backgrounds. And that's to say the same for learners, the benefit that comes for those learners that may not have any special needs to be engaging with learners from different backgrounds. And then lastly, just to say, equality requires us to break down patterns of disadvantage from forming. Many learners are not only denied the right to basic education, they continue to suffer stigma, stereotyping, socioeconomic disadvantage, violence, and powerlessness as a result of their race, gender, disability, sexual orientation, or other group membership. So equality requires that we break down these patterns of disadvantage. And then I think it's just to note, and coming from Chapter 5 of the Equality Act, other ways where we have seen promoting equality and trying to break down these patterns of group disadvantage. For example, if we think about the National School Feeding Scheme, where there was an order that was just confirmed again today. But just to say that, learners that may not necessarily have had a hot meal in the day, with this feeding scheme, they're able to get the meal that they need and to be able to which is very important in trying to get through a schooling day. Free education, and improvements in teacher qualities, where we've seen with the different bursaries, for example, the Funza Lushaka bursary scheme, trying to improve and the teacher quality. So it's just understanding, just those are just a few points on sort of equality in education and the importance of it. So yeah, what I was asked to speak a little bit more, I just now want to go into a little bit more of the law, which is so the legal framework which protects the children against discrimination in education in respect of HIV and TB. I had put down here the Children's Act, but I think that Morgan has covered that quite significantly. And it was just to say, especially in the schooling context, that because there was the point about testing and when that could be done. And so it's important to note that schools, although the Act does list exceptions and when it can be done, or when someone can be not forced, but when testing should be done, what the exceptions are. But from the outset, schools shouldn't be forcing learners to be taking HIV tests, and that's something important to know. And then also just the point that Morgan covered under Section 133, which dealt with consent, which is to say that, once, for example, if a principal does become aware of the learner's HIV status, that this information is not meant to be told to any other of the teaching staff. So it's important that that this information is not disclosed without the consent. And here again, there are certain exceptions, but in the schooling context, that information shouldn't be known to all of the school. Then I think the next piece of legislation that sort of protects from HIV discrimination is the South African Schools Act. It does specifically say in its preamble that this act requires a national system of schools which will redress past injustices in the educational provision, provide an education of progressively high quality for all learners, and in so doing so lay a strong foundation for the development of our people's talents and capabilities, advance the democratic transformation of society, combat racism, sexism, and all other forms of unfair discrimination and intolerance, and contribute to the eradication of poverty. So in the Schools Act itself, there's an acknowledgement that there is no place for unfair discrimination in the school system. Specifically, Section 5.1 of the Schools Act provides that a public school must admit learners that serve their educational requirements without unfairly discriminating in any way. And that's obviously sort of the guiding piece of legislation for all schools, which does prohibit then unfair discrimination. The other piece of legislation that I pulled out was the National Education Policy, which sort of just, again, would just guide that any policy that is developed by the Department of Education would be guided by this particular act. And here it's to say that it's to adopt legislation to facilitate a democratic transformation of the national system of education into one which serves the needs and interests of all the people of South Africa. And in Section 4, where it speaks about the directive principles of this particular act, it does include that every person to be protected against unfair discrimination within or by an education department or an education institution on any ground whatsoever. So there is also that protection against unfair discrimination in that act. And then I think the next piece of legislation is the Employment of Educators Act. And I think this is important because now we're getting down to the nitty-gritties and the staff that are engaging with our learners and where we might come across quite significant problems. So it's important that this piece of legislation also specifically prohibits unfair discrimination on grounds which includes HIV. In the Employment of Educators Act, is to provide for the employment of educators by the state for the regulation of conditions of service, discipline, retirement, discharge of educators. So all matters connected to the educators. And what it specifically does in this act is under Section 18K, it classifies, it defines unfair discrimination as a grounds for of misconduct. It specifically says unfairly. So it would be if an educator unfairly discriminates against other persons on the basis of race, gender, disability, sex, list the grounds which do include HIV status. And then what it does further in section 18, specifically 18.5c, is that because obviously unfair discrimination would be misconduct, that unfair discrimination is then a grounds for dismissal in terms of this act itself. Obviously, following the disciplinary processes that would be also set out with this, but it's important to know that employers are specifically required to make sure that they're not unfairly discriminating against the learners. And I think this is important because we're putting our children in school. We understand that the employers, I beg your pardon, the employees, so the educators and the staff the educators are in a role of locus parenti, and they are, they're meant to be in a position where, when the learners are away from their parents, the educators sort of step in and guide and do what needs to be done. So the role that the educator plays when the learner is in school is very important, and to make sure that that the learner is able to properly achieve the right to education, that they're there to do so in a safe learning environment. I also just put down the South African Council of Educators. I didn't specifically say, sort of in those very specific words, unfairly discriminate, but the South African Council of Educators is the body that governs all educators in our country. And they have a guiding sort of ethics principles that they are meant to comply with. And it's important to note that, there would be certain principles and ethics that they would need to comply with as well in terms of the South African Council for Educators. If we go into sort of policies, having just speaks about a few pieces of legislation, if we move down to policies, we specifically have the schools admissions policy for ordinary public schools. And this is clear that this admissions policy for public schools and the administration of admissions by the Education Department must not unfairly discriminate in any way against an applicant for admission. So no discrimination on the basis of one's HIV or TB status. And then the other policy that it sets out what needs to be done is specifically the policy on HIV, STIs, and TB for learners, educators, school support staff, and officials in primary and secondary schools in the basic education sector. So this policy was developed, I think it was in 2017, and so it's important to know that what has been trying to achieve here is improve coordination and mainstreaming of the basic education sector's response to HIV, STIs, TB, and to increase knowledge, cognitive skills, and information about safer sex life skills in general, and then HIV, STIs, TB in particular. Improve access to HIV, STIs, and TB prevention, diagnosis, treatment, and care support, and then increase retention of learners, which is obviously quite significant, educators, support staff, and officials in the safe and protective education environment, as well as improved registration of learners to improve system efficiency, quality, and output. So what we see in the HIV policy is that it does give sort of its guiding principles. And obviously one of the important ones is access to information, right? Every person of school-going age has the right to basic education, and no learner should be denied basic education on the basis of actual, and they also do say perceived, HIV or TB status, which is important. That also one of the guiding principles is obviously also access to information, that every person in the basic education sector has the right to access to relevant, factual, comprehensive sexual education. And I think this is where we see, because part of promoting equality is obviously to make sure that is education and awareness and information. And so the content and what's covered in the comprehensive sexual education is very important for not only the educators, the learners, in understanding, testing, prevention, and all related to HIV, STIs, and TB. And we do see that taking place. There's also just been some significant developments. For the most part, Section 27 is at loggerheads with the Department of Education. But in this particular instance, on comprehensive sexual education, this is actually something where we applaud the Department of Basic Education for what they've done in this particular instance. So, and we continue to sort of monitor and see how that's been going. And then I think another guiding principle is equity and protection from stigma and discrimination, which I think, sort of speaks for itself. And I think here again, it also speaks about the perceived infection of HIV or TB status. Other guiding principles include privacy and confidentiality, I think, which Morgan touched on quite significantly. I think obviously with TB, it is a notifiable disease. So I think it's quite distinct from HIV. But for the most part, the right to privacy is quite significantly involved. And it isn't something that needs to be sort of disclosed willy-nilly in the schooling space. And then the other point, which I touched on previously, which is another guiding principle, is reasonable accommodation, that learners, educators, support staff, and officials diagnosed with TB should not attend school or basic education workplaces during the period that they're deemed to be most infectious. And then similarly, learners hospitalized for extended periods of time, whether for treatment of HIV, STIs, or TB, that they continue to have a right to basic education, and the school concerned will take steps to accommodate their learning needs appropriately until they're able to return to the classroom. And I think that's important because, it's taking those steps. I think similarly, we see that with for example, like the pregnancy policy, school pregnancy policy, where the learner is out of school, to make sure that that learner is still able to receive the information that they need to for classes, so that they can receive their right to basic education. So I think those were the sort of the pieces of the legal framework that I was able to pull together in terms of, protecting learners from discrimination on the grounds of HIV. I think that's me for now.
Thanks, Shanice. Now we get to start with the questions. I don't know if the two of you can see the questions here on the side, but I'm just going to read it out so that it's also there for the video on YouTube. So this is from Portia Tsuro. In relation to the first presentation, so that's you, Morgan, where children are allowed to consent to their HIV testing and have their status kept confidential, even to their parents or guardians, what interventions have been put in place for these children to fully support them in terms of administering medication and supporting a healthy diet? How is this possible without the carer knowing?
I think that's a very good question. And once again, it is a question without a very easy answer. Hopefully in those kind of situations, the child would have confidence in his or her caregiver, and would then disclose that particular fact to him or her in order to receive, support, and the love and support that a child would need, especially if they had tested positive for HIV/AIDS, would be incredibly high. Insofar as the question seeks a legal answer, the child themselves would be obviously able to access, depending on where on the spectrum they fall. You'll recall that there are defining age limits, but would be able to access, at least insofar as medication is concerned. They'd be able to access medication from whatever facility is treating them. Insofar as dietary requirements are concerned, once again, a child would obviously need a caregiver or a parent or someone in that capacity to assist. So it makes it factually quite difficult for them to withhold that information from the person who is actually providing that particular service. But as a matter of law, if the child did not wish to disclose that status, then that would just simply be the end of the matter.
Okay. And then to both Morgan and Shanice, we've got a question here from Teresa. What is the legal obligation of the healthcare provider and schools if the child has been abused and has HIV/AIDS as a result of the abuse?
I would probably tend to suggest that in that event, the mandatory disclosure provisions, insofar as the sexual offence is concerned, would need to be processed. So they would be under an obligation to notify a social worker, who would then investigate and make whatever complaint to the South African Police Service. Whether or not the HIV/AIDS status is to be disclosed, that is part of the kind of exceptions, and when that can be disclosed in terms of Sexual Offences Act, because it obviously impacts on the severity of the offence, the transmission of HIV and AIDS. But insofar as the legal obligation is concerned, a healthcare provider and educator are both legally obliged to disclose the commission of a sexual offence that has been, or that they have learnt of, to the relevant authorities for there to be a proper investigation going forward. I'm not sure if Shanice can add to that. I'm sure she has a wealth of experience in that field, especially in the education sector.
Thanks, Morgan. Yeah, I think, just to reaffirm what you said, and then specifically the reporting obligations that would be required in terms of the Sexual Offences Act. There are, in addition to it, certain protocols that are in place within the education space, which do require, that do set out what steps that educators specifically should take in terms of once they have been informed of a case of sexual harassment or sexual violence in the schooling space. And yeah, it's very detailed in terms of what's to be done. Problem is, whether it is being done by the educators. I think we've seen Morgan and I have actually been working on one particular case, which is terribly unfortunate, but we see that educators, unfortunately, principals just don't come to the party in terms of what needs to be done. And so, I think it really does need to be, it needs to be a little bit more set in stone, or there's several measures that need to be put in place to get these things done so that they're properly implemented by the educators that are meant to be ensuring that our learners are receiving education in a safe learning environment.
Are there any other further questions from the participants this morning? Morgan, I just had a question for you. When you were speaking earlier about the, how does a medical practitioner determine maturity? You said that it's something that you're looking into. So are you thinking that this will take the form of some sort of litigation, or is it going to be advocacy, in terms of campaigning for change?
at this point in time, it's more conceptual. It's an area that we have flagged that may very well need either some form of advocacy or some form of litigation going forward if a case presents itself. But it is an area where there is the possibility, at the very least, that children might be falling through the cracks in those kind of situations. So it's an area that we're interested in. It's an area that we hope to kind of interrogate in a bit more detail, and then, you know, depending on the need. I mean, obviously we all have resource constraints, unfortunately, and you know, to the extent that cases start featuring that have the hallmarks of those problems, then obviously we would do something concrete about it. But for now, it's kind of more of a research focal area to try and understand if it is in fact a problem. But like I said, those kind of cases, we don't hear of them very often. I haven't heard of that, a particular case like that. But it is definitely a case that I'm sure has happened. And it's just about trying to find out the prevalence of that going forward.
Right. And then on the issue of confidentiality and the child having an absolute right to privacy, I recently looked at a school admission form. It was actually the contract, and it said the parent or guardian grants consent to the school to share information amongst teachers and staff if it is in the best interests of the child. And then it doesn't go on to specify but this excludes HIV/AIDS status or whatever. So, I mean, what is your experience in what is happening? Are teachers disclosing HIV/AIDS status? Do we need to update school policies that specify what exactly can be shared amongst teachers and staff?
I definitely think that there is a need for some form of ministerial directive dealing with what can and cannot be disclosed. My view is simply that teachers, well, particularly with HIV and AIDS, the legislation, to my mind, is quite clear. You cannot disclose that information unless it falls into one of the exclusions, and simply an application form where a parent is just signing away their child's right to consent to that would never hold up, and would be constitutionally impermissible in my view. So I would probably venture to suggest that there is a need for some form of directive, particularly around privacy concerns. I mean, I think that the more and more you delve into kind of a child's innate right to privacy that we all have, but somehow we think as children have less of a right to privacy. I think there is need for directions, but I think Shanice probably can weigh in here insofar as particularly school policies and the sharing of, I guess, information outside of the kind of HIV/AIDS debate, because I think that's quite clear. But I'm sure that she has some insights into that.
Thanks, Morgan. Yeah, Chantal, I think I do appreciate that, you know, some sort of directive would be helpful. I think you find situations where, you know, it's like, you know, you get those situations where parents are coming, they've given a form and they, you know, just sort of, you know, sign the rights away. And it's something that is quite concerning that we do also need to be mindful of. I think, and I think we did speak about this sort of briefly, that specifically on issues of HIV, in my experience, unfortunately, we haven't seen any issues like this, whether it be sort of access to schooling or issues of sharing this information or disclosing this information in the school space. It isn't something that has been brought to the attention of Section 27 in my experience. But I think for things like, because one area of our work as well is sexual violence in schools. And I think, you know, things like that also very the confidentiality and privacy of the child. But I think, you know, it's things like that where you can see that specifically amongst the school staff, or maybe with a class teacher or something like that, you could understand the need why there may be a need to just inform from the principal to the class teacher that this particular incident has happened. For example, maybe the learner transferred and due to you know, an incident of sexual violence in schools, and they may want to just sensitize the class teacher to this information. In my mind, it's things like this that would serve the best interest of the child at the end of the day, which obviously we would come into play. So, but specifically on HIV, I think, fortunately, or maybe it's just because, you know, an issue of reporting is another thing, but we haven't seen it to be too significant of a problem in the schooling space. Yeah.
I think that touches on what Morgan said in his presentation about, is it a problem? Is it a perceived or a real problem? And I think that's something we've encountered throughout this project is a lot of people say, but I thought we combated HIV AIDS. Government has a lot of policies, we test, it's become very normal. But then when we have these type of presentations, then some information comes forward about discrimination that continues, domestic workers that are fired because of their HIV status and parents not wanting them be exposed to the children. And then suddenly it comes to the fore. And that's also been the purpose of these webinars, is that attorneys, legal practitioners in general, campaigners get to exchange ideas, and that it gets put out there so that, you know, we can go to people like Morgan and say, look, here are the cases, can you help? Because at the moment we don't know what's real or what's perceived. So I've just got another question here from Natalie. Correct me if I'm wrong, but if a child tests positive, would the child get the same medical treatment as an adult, for example, the ARVs, and would the process be the same? Shanice, I don't know whether you would have information on that.
I think my information base specifically on the ARVs and the treatment is very basic. But my understanding is that, yes, I'm not sure of the dosage. It might vary, but I think it is essentially the same as what would be prescribed for an adult in terms of, for example, PEP, PrEP, all of those things. Yeah, I think Morgan may be able to help me a little bit more with that, but that's my understanding.
Yeah, I think, Shanice, I agree with you. I think that insofar as the clinical prescription of medication is concerned, I mean, I don't know what dosages would follow, but yes, a child would be entitled to the exact same kind of quote unquote medical treatment as an adult would, obviously measured correctly to the fact that they are children and not adults. But insofar as access is concerned, yes, they would have access to whatever treatments are available and are suitable for children. But like I said earlier, is the anomalous situation that can arise, that is where the particular child falls into the gap that exists in the Children's Act between the age of 12 or below the age of 12 and being able to consent to his or her own HIV testing, and the need for parental consent if you're under 12 for medical treatment. So obviously anything that follows a positive diagnosis, you would then need to engage with whatever the medical treatment that is prescribed by the doctor. But that actual process, if you're under the age of 12, would need to happen with parental consent going forward. I don't know if that answers Natalie's question.
Yeah, I'm sure that's fine. Okay, so I don't see any further questions. So I'm just going to thank Shanice and Morgan. Thank you very much for joining us this morning and for this very informative discussion. The webinar will be posted on YouTube, and we will be sending out links for everyone to watch later. And if you'd also just like to share it with your colleagues. And then we just want to show you that all the resources have been added to probono.org's website. They've recently updated it. So all the so we've been updating the website with the legislation, with relevant case law, with policies, as well as sort of research in the international sphere, especially around how COVID has affected the HIV/AIDS program. And so you can just find everything on the website. And if there's something you'd like us to add or look for, then please just get in touch with us and we'll add it. So without further ado, I'm going to wish you a wonderful day, and thank you very much for joining us. And we will be having further webinars in future. Just look out for it in your inbox. Okay, thank you very much.
Thank you.
Thank you so much.
Thank you. That was awesome.
Thank you, everyone.
Thank you. Bye.
Thank you, everyone. Bye.